SwayamPrabha. Digital India. Educated India.
Hello friends, welcome to the 15th lecture of our course on law of copyright, patent, trademark and other IP. As I said in the last lecture that we have concluded our discussion on patent law. In first few lectures we discussed the aspects of copyright, then we finished our discussion on patent law, and as I said, the next 4 lectures will be on trademark, followed by 2 lectures on other forms of IPR, which will include some discussion on geographical indication, some discussion on the industrial design, and there will be 1 full lecture on protection of plant varieties and Farmers' Rights Act. So now we will start with the trademarks law, and this lecture is on meaning of trademark and concept of distinctiveness. Let's start our discussion. Trademark is any mark which a trader uses in the course of trade to distinguish his goods and services from goods and services of other traders. That is the basic meaning of a trademark. It's a mark which a trader will use in the course of trade for the purposes of distinguishing his goods and services from goods and services of other traders. Now, if you see, there are some preliminary observations. The first point is that a trademark is a visually perceptible sign. Visually perceptible sign is something which can be seen and it is used in relation to goods or services. The primary purpose of using trademark is to identify the trade origin of the goods, as to the goods or services are coming from which trader, the trade origin of the goods. As I said, the most important job which trademark does, it distinguishes goods and services of one trader from goods and services of other traders. And therefore, it helps the consumers in making informed decision. It helps the consumer in purchasing the goods on an assumption, on an assurance that all the goods bearing that particular trademark will have that consistent quality, will have a particular composition, etc. So therefore, it is visually perceptible sign, 1. 2, it identifies trade origin. 3, it is used to distinguish my goods from your goods, and it helps consumers in making decisions. Trademark in a way reflects goodwill or a reputation of a particular product. In the Trademarks Act 1999, we will see that registered trademarks will get protection under the Trademarks Act. However, it is not mandatory to register a trademark to get any protection. Even unregistered trademarks, we will see in next lectures, even unregistered trademark will get protection. You must have seen 2 symbols. One is R inside a circle, the other is TM inside a circle. The first symbol indicates that the mark is registered. The second symbol indicates that it is not a registered trademark. However, the trader is claiming that mark to be his trademark. The only thing which the Trademarks Act 1999 does, as I said, whether it is registered or unregistered, you have some protection. But if it is a registered trademark, you get a better protection. Better protection of trademark for goods and services and for prevention of the use of fraudulent marks. So, what the Act of 99 provides for is a better framework for protection of registered trademarks, although we have some protection even for unregistered trademarks. So, this is the basic background against which we will try to understand the meaning of trademark, the various kinds of marks which we have defined in our Trademarks Act, the function which the trademark performs, and the concept of distinctiveness. The trademark has been defined in section 21ZB of the Trademarks Act 1999. Trademark means a mark capable of being represented graphically. So, there are two things. One, it has to be a mark. We will see how the word mark will be defined. And the second important thing is capable of being represented graphically. You must be in a position to write it or draw it or paint it, show it, visually perceptible. So, graphical representation indicates that the mark must be visually perceptible and which is capable of distinguishing the goods or services of one person from those of others. So, the third thing is distinctiveness, the ability of that mark to distinguish goods and services of one person from that of another. So, it must be a mark, it must be capable of being represented graphically, and it must have that ability to distinguish my goods from your goods. Then it qualifies to be called as a trademark according to section 21ZB. And then you have inclusions, shape of goods can also be a trademark, packaging, combination of colors, these can also be trademarks. So, I said there are two basic requirements. One is capable of being represented graphically, the other is capable of distinguish goods or services of one trader from the goods and services of other traders. A trademark is something which we use in the course of trade. And what do we mean by this phrase, in the course of trade? A trademark is visually perceptible, a trademark is capable of graphical representation, a trademark distinguishes one trader's goods from other traders' goods. A trademark is something which traders use in the course of trade. What do we mean by this phrase, in the course of trade? It is written here. A trademark is used in relation to goods or services for the purpose of indicating a connection in the course of trade between goods or services and some person having the right as proprietor to use the mark. So, this is what? This is indication of trade origin. There is a connection between goods and services bearing that mark with the proprietor of that mark. The trade origin is disclosed by the use of trademark. This is what I mean when I said that the mark is used in the course of trade. So, a mark is used in the course of trade means it establishes the link between the goods and the proprietor of the trademark. We said a trademark must be a mark. If you go back, the first is trademark is a mark. Second is graphical representation. Third was capable of distinguishing. Fourth is used in the course of trade. Now, let us see what is the first point. A trademark is a mark essentially. A mark has been defined in 21M and it is inclusive. It includes device, brand, heading, label, ticket, name, signature, word, letter, numerals, shapes, packaging, combination of colors, any combination thereof these. There can be a word as a trademark, there may be a composite trademark consisting of some pattern, some color combination, some words, some pictures. So, mark may include any one of these or a combination of these. Signature, for example, if you take signature, this is the most distinctive thing I can have. My signature is most distinctive. Signatures can be very good trademarks, but the problem with it is how do you pronounce a signature? So, therefore, although it is graphically represented, although it has distinctiveness, but how will you pronounce it when you have to purchase goods bearing my signature over a counter? So, many other factors will also come into picture when you decide what should be your trademark. So, it has to be essentially a mark, and mark means one of these. Trademark can be conventional trademark, can be a non-conventional trademark. 2017 trademark rules introduced many non-conventional trademarks which is acceptable in India now. Let us see what are these non-conventional marks. Conventional marks are not difficult to understand. Any word, any name, any slogan, any ticket, any label, any packaging, any combination of colors, any combination of all these devices which I mentioned. These are conventional marks. Non-conventional marks can be visual, can be non-visual. Visual marks are perceived visually. This can be seen and understood via graphic cues. These are visual trademarks. For example, trade dress. You have something, a new thing coming as motion marks. I'll talk about it. You have color marks, combination of colors. You have hologram marks, position marks, etc. These are visual, unconventional marks. These are visual, unconventional marks. I'll talk about one or two of these. Non-visual trademarks are those trademarks which are perceived by senses other than eyes. These are not visually perceived. For example, you have sound marks. You must have heard certain tunes of certain brands which are registered. You have smell marks, olfactory marks, smell marks. There may be texture marks, taste marks, and you have unlimited possibilities here. But it is relevant to see as to what all kinds of non-visual, unconventional trademarks are acceptable in Indian law. So we have understood what is a trademark. We understand what is a mark now. Mark can be conventional, non-conventional. Non-conventional can be those which are visually perceived, those which are not visually perceived, which are perceived by other senses. Trademark Rules 2017 allows for registration of sound marks now. Now, how do we satisfy the requirement of capable of being represented graphically? How do we satisfy the requirement of graphical representation? The Trademark Office will require the proprietor to submit sound marks in MP3 format. And this format is sufficient to satisfy the requirement of graphical representation. We accept that capable of graphical representation is satisfied. 2017 rules also allow for registration of combination of colors. Further, it also allows for registration of motion marks, moving marks. How? Under the rules, a trademark can be represented graphically through a set of pictures, continuous snapshots of the moving mark, and the description allowing for registration of motion marks. So, what do the trademark offices require? They will require continuous snapshots of that moving mark. And that is how they accept that the requirement of graphical representation is fulfilled. So, therefore, there are two new things happening. Sound marks are registrable in India. Motion marks are registrable in India. On the other hand, graphical representation requirements is not fulfilled by smell marks, taste marks, and therefore, these are not registrable under Indian law. In some foreign jurisdictions, you will find these smell marks and taste marks as given registration. There is a case which I have mentioned here, Zippo Manufacturing Company versus Anil Mulchandani. This is the case in which the respondents were prohibited from selling lighters with Zippo mark and 3D shapes similar to that of Zippo's lighter. Delhi High Court held that such use constitute infringement of plaintiff's shape mark. So, we are moving in the direction of recognizing more and more non-conventional trademarks. Much is needed in 2017 rules to incorporate space for registration of smell marks, taste marks, etc. but the biggest challenge is fulfilling the requirement of capable of being represented graphically. So, if we understand what is the meaning of a trademark, what is a mark, what are conventional marks, what are non-conventional marks, what is the requirement of being represented graphically, if we understand basic points in the definition of trademark, we can go on to the other forms of marks which are registrable under Indian law. The next is certification trademark. Certification marks are essentially trademarks that are used to certify that the goods or services on which they are affixed comply with certain quality standards prescribed by the certifying entity. So, there is a certifying entity, and any agency, any person, any trader, any goods bearing that certification trademark is complying with the terms and conditions or the quality standards as laid down by that organization, that entity which is certifying the same. So, certification trademark is owned by that entity and it is affixed by the traders on their goods and services if they comply with the quality standards of that entity. The registered proprietors of certification marks are not allowed to use them in relation to goods or services that they themselves offer. This is not a case. It is for the others who comply with those standards, they will be using the certification mark as if the quality is certified. Section 2(1)(e) defines certification trademark. Certification trademark means a mark capable of distinguishing the goods or services in connection with which it is used in the course of trade, which are certified by the proprietor of the mark in respect of origin, material, mode of manufacture of goods or performance of service, quality, accuracy and other characteristics from goods or services not so certified. So, therefore, if I am using some certification mark, it is certification of performance of goods, quality, accuracy, material used, origin, mode of manufacture. I am complying with the standards of that proprietor. For example, ISI marks are good example. Any goods bearing ISI mark means it complies with the standards of the proprietors of this certification marks. Now, if you see, proprietors can only license the certification marks to others to use them, while ensuring that they observe due compliance with the standards of quality and assurance as set by the proprietors. Under Indian law, a person or entity seeking to register a certification mark has to file an application in the prescribed form with the prescribed fee before the Indian Trademark Registry in class of goods and services for which they want to register it. In addition to these, the application must also include the draft regulations governing the criteria for licensing such a mark and its permitted use. What are the conditions, what are the criteria for getting license of these certification mark? What are the conditions governing use of these certification mark? Who can use it? Under what conditions they may be allowed to use it? What are those conditions which they must definitely achieve in order to get the license to use these certification marks? These draft regulations must also be supplied along with the application for registration of certification mark. Now, in case of certification mark, the remedy for infringement is not different from any ordinary trademark. You see, it may not be a kind of regular trademark which we defined, but the remedy remains the same. For example, the High Court of Calcutta in the case called as Tea Board India versus ITC Limited observed that in infringement action, in order to be successful, the claimant has to prove the infringement in the same way it is proved in case of any other trademark. So, certification mark is something which certifies the quality, and the users will have to comply with the standards laid down by the entity, the proprietor, in order to be able to use the certification mark. I already gave you the example of ISI. The next word is collective mark. A collective mark is used by members of an organization collectively to identify goods and services and to distinguish them from those of non-members. Act defines collective mark in section 21G. Collective mark is a trademark distinguishing the goods or services of members of an association of persons. That association of persons is the proprietor of that mark. So, association of the goods belonging to association of persons, every trader who is part of that association is using it, they are using it collectively. Collective marks are a distinct kind of mark under Trademarks Act. They serve a very unique purpose, a specific purpose. And the main goal of collective mark is, one, to inform the public about a particular aspect of an organization, its members, and the services and goods they provide that are associated with the mark. And two, comparing the quality of each organization's members' products and services, if any, you can distinguish between them. So, a collective mark is used by members of an organization collectively to distinguish goods and services from the goods and services of non-members. A certification mark is a mark owned by an entity, and any trader which complies with the requirements of that entity will be given the license to use it. Whereas a collective mark is owned by the association of members. I am a member of that association. So, that is how these two are different. So, therefore, we understood 3 points: trademark, which includes meaning of mark; second is certification mark; and third point which I discussed is collective mark. The next point is honest concurrent use of trademarks. See, I have given two illustrations here on this slide. First is when you have two traders using the same trademark in their respective territories, respective localities, because these are very far away from each other. So, therefore, in early days there used to be no question of deception or confusion arising because of two traders using the same trademark. But when markets started to expand, goods came to be sold to the same potential buyer. The buyer may purchase goods from different markets, and in that situation, possibility of confusion, possibility of deception may arise. I am talking about more than one trader using the same trademark. Can that be allowed or not? One situation where this should be allowed is when two traders are using it independent of each other, and they have been using it since time when there used to be no deception. What do we do? Second, which is very common, when one trademark may be acquired by more than one successor. Suppose the business is divided. In the second generation, the business is divided. More than one person has inherited part of the business. Then in that case, both the groups would like to use the same mark. And in that situation, there is a risk of deception. Now, in both these cases, there is no dishonesty involved. These are instances of concurrent use when more than one trader using the same trademark. At the same time, these are instances of honest use. Now, in these two cases, more than one proprietor is given protection for the trademark, and which becomes necessary because of events which did not involve dishonest or wrongful conduct on the part of any of the persons involved here. Now, while allowing protection for such concurrent uses, some factors may be relevant. First, whether the concurrent uses are done honestly, quantum of concurrent use, degree of confusion likely to emerge, and a very important point, the relative inconvenience which would be caused to the parties. If I take your trademark, what will be the inconvenience caused to you? If I take back the trademark of other group, what will be the inconvenience caused to that other group? So, the relative convenience will also be a factor. Keeping in mind these four factors, we can decide whether to allow the two traders to use same trademark concurrently or not. Public deception, of course, is an important factor, but honest use is also an important factor. So, therefore, trademark, certification mark, collective mark and marks can be used concurrently provided the uses are honest. Why are we protecting trademark? Why are we protecting trademark is a very important point we must know before we go on to discuss other concepts like distinctiveness or registration of trademarks or infringement or passing off or remedies. Why should we protect trademark? Because if you see, law does not permit anyone to carry on his business in such a way as would persuade the customers or clients in believing that the goods or services belong to someone else. I should not pretend that the goods which I am selling belong to some other business group. Or I should not pretend by my conduct that I am associated with some business house. Why law does not allow me to do it? Law does not allow me to pretend by my conduct that I am selling somebody's goods, somebody else's goods, or I am somehow associated with some other trader. Why does law prohibit? Because first, honesty and fair play are the basic principles in the world of business. And second, when a person adopts or intends to adopt a name in connection with his business or services, which already belong to someone else, it results in confusion and has probability of diverting the customers and clients of someone else to himself and thereby resulting in injury. So, if I am adopting a name which belongs to some other business group, I will end up creating confusion and I also divert the customers from that business group towards me. Now, these are not fair play, these are not honesty. So, the most important objective as to why should we protect trademark is to ensure fair play and honesty in the world of business, right? What are the specific functions which trademark performs? As I already mentioned, it identifies the goods or services of one trader from others. It distinguishes goods of one traders from others. It signifies that all goods bearing a particular trademark come from same source or origin, trade origin. So, it identifies, it distinguishes. Second, it tells me the trade origin. What is the source of those goods? It assures me about the quality, it gives me assurance. It is a very good advertisement tool. It advertises the goods or services and assists the consumer in making decisions about purchasing goods. So, it is a very good tool to advertise your products and services, and it reflects goodwill and reputation of particular product. So, these are the 5 basic functions which trademark performs. It distinguishes goods and services of one trader from other traders. it tells me the trade origin, it gives assurance to the customer that whatever they are buying will have a certain quality and consistency. It's a very good advertising tool, and last, it reflects goodwill or reputation of a product. So, we understand what is the meaning of a trademark, we understand what are the functions of a trademark. Now, let us see what are the prerequisites for registration of a trademark. From here till the next lecture, we will only be talking about registration and registrable trademarks. What trademarks are registrable? I have already mentioned the basic qualification for registrability of mark is contained in the definition of trademark itself. The basic qualification of registrability of a mark is contained in the definition of trademark itself. The basic requirements are, it must be capable of being represented graphically, and it must be capable of distinguishing the goods or services of one trader from another. Thus, whatever mark is not prohibited from registration is registrable if it satisfies these two conditions. In the next lecture, we will see there are certain marks which are prohibited from registration. These are contained in section 9, which talks about absolute grounds for refusal of registration. Section 11, which talks about relative grounds for refusal of registration. We will talk about these in detail in the next lecture. Now, what I mean to say is, any mark which is not prohibited from registration is registrable if it fulfills these two requirements which are there in the definition. So, now if I summarize, what marks are registrable? What are the prerequisites for registration? The mark must be distinctive. The mark must not cause confusion or deception. The mark must not contain scandalous thing or obscene matter. The mark must not hurt the religious susceptibilities of any class or section of public. Now, out of all these, this is one point which I would like to elaborate in this lecture, and remaining will be discussed in the next lecture. So, what are the prerequisites for registration? A mark is registrable if the registration is not prohibited by virtue of sections 9 and 11, provided the mark in question has these two capabilities, that is, capability of being represented graphically and capable of distinguishing the goods or services of one trader from other traders. There are few points which I have mentioned. It must not cause confusion, it must not cause deception, it must not contain scandalous, obscene material, it must not hurt the religious susceptibilities of any class or section of the public. Most importantly, it should be distinctive. It should be distinctive. What do we mean by distinctiveness? So, the key term here is distinctiveness. Now, if you go back to our introductory lecture, I said that every IP law is by and large structured in a similar form. The first thing which any IP law will do is to identify the subject matter. For example, if you recall, in copyright law, I said works are protected, but not all works are protected. In order to get protection, your work in question must have originality. Similarly, in patent law, we discussed patent law. We said invention is the subject matter of Patent Act 1970, but not all inventions will get patent protection. The invention in question must be new, it must have inventive step, it must have industrial applicability. We saw certain keywords. We will see in Protection of Plant Varieties Act, not all varieties are protectable. The variety in question must have uniformity, distinctiveness, stability, novelty. So, every IP legislation will have certain keywords to identify the subject matter which is protected in that legislation. In Trademarks Act, the keyword is distinctiveness. Let us understand this keyword distinctiveness. there is something called as descriptive trademark. What do we mean by descriptive trademark? A trademark which describes, identifies the characteristics of the product or services to which the mark is applied. So therefore, you write a word "right" on this pen and claim that word "right" to be your trademark means, what is this pen? What is this pen for? This pen is going to write and you are using the word "right" as trademark. This word is describing the quality of this product. It identifies the characteristic of this product. A mark is descriptive if in its common use it is reasonably indicative of the thing it's intended to be used for. Right? So therefore, any word which describes the quality, which indicates the intended use, is a descriptive word. It is implied that a word which has only an indirect reference to the character and quality of goods does not qualify as descriptive word. For example, if I write "smooth" on this pen, one can argue that smooth indicates that the pen will write smooth. But at the same time, there may be a counter argument that this is not the direct indication of the purpose which this pen performs. So one may argue that it is only an indirect reference. So therefore, any word which only indirectly refers to the characteristics of that goods may not be called as a descriptive word. If I am only suggesting and not describing, if the word is merely suggestive, it does not make it an inappropriate word to be registered as trademark. There may be suggestive words which may become registered trademarks. It has always been held that a word which consists of the name or description of the goods, pen cannot be the trademark of pen, TV cannot be the trademark. So a word which is the name of the goods cannot be a trademark. Even if a word which is the name of that product cannot be a trademark, even if there is only one trader who is manufacturing those goods. Try and understand. If I am the only trader who is manufacturing, say, a toothbrush, and I want to use toothbrush as the trademark for my product, even in that case I am not allowed. Although there is no likelihood of confusion because I am the only trader who is manufacturing and selling, still such a word cannot be allowed to be used as trademark. So first point which I want to make here is that the words which describe the characteristic of a product are not fit to be considered as a trademark, because such words would lack the capability to distinguish your goods from goods of others. Descriptive marks should not be allowed to be registered under section 9(1) of the Trademarks Act. Another point which I have mentioned here, if a mark is descriptive per se, it is a descriptive mark, but owing to its prolonged use in the trade, it has lost its primary descriptive meaning and has become distinctive in relation to goods it deals with, it can be registered. Although there may be a word, for example, bright. Bright describes the quality of the product, but because of long use of that product, it may happen that bright loses its primary meaning as bright and acquires a distinctiveness. In such a situation, even such descriptive words may also be considered for registration. In the case of Marico Limited versus Agrotech Foods Limited 2010, the Division Bench of Delhi High Court held that when the descriptive trademark is used only by one person undisturbed for a long period of time without anyone else attempting to use the trademark during this long period of time, a case can be established of a descriptive word having achieved distinctiveness and a secondary meaning. This can be a case of registration of trademark. Although Originally, the word was a descriptive word, but because of single use, continuous use, prolonged use, nobody else is coming up to use the same word. Because of that, it may happen that it loses its primary meaning and acquires a secondary meaning. And with passage of time, trademark gets strengthened, may be considered fit for registration. So therefore, try and understand, some trademarks are distinctive since its inception because of inherent character, and they are given legal protection immediately. And there are certain trademarks which are inherently not distinctive because, for example, they are descriptive, but because of long use, they may acquire distinctiveness. So there are two words I am referring to. One is inherent distinctiveness. These are good trademarks which are inherently distinctive since their inception. And second is acquired distinctiveness. There are certain words which are descriptive, which are laudatory. For example, quality is a laudatory word. I am using it for last 50, 60 years. It may lose its primary meaning, acquire some secondary meaning and become distinctiveness. Become distinctive. So therefore, there are marks which are inherently distinctive and there are marks which are distinctive which they have acquired. Second, another aspect is there are some words, although primarily descriptive of character and quality of goods, may lose the descriptive meaning and has acquired some other meaning. The Trademark Act 1999 indirectly deals with acquired distinctiveness or secondary meaning under proviso of section 9(1) and section 32. There are certain words which lose their primary meaning and acquire distinctiveness. These are those words which are inherently not distinctive, maybe because they are descriptive, but they lose their primary meaning, acquire secondary meaning, get distinctiveness, and now they become registrable. The possibility is there in proviso of section 9(1) and section 32. The registration of descriptive trademark is prohibited otherwise in 9(1)(b). We will talk more about it in the next lecture. The registration of descriptive mark is prohibited under section 9(1)(b). However, proviso to 9(1) provides that a trademark shall not be refused registration if before the date of application for registration it has acquired a distinctive character as a result of the use made of it, or if it is a well-known trademark. I will talk about well-known trademark later on. So, even if it is a descriptive word, there is a possibility of its registration which is provided in proviso to section 9(1). What are the criteria of distinctiveness? How do we judge distinct character of a mark? There are 5 factors which I have listed here. How do we decide whether the mark has distinctiveness? First, the market share held by the mark. Second, how intensive, geographically, widespread and long standing use of the mark has been. The amount invested by the undertaking in promoting the market, the proportion of the relevant class of persons who identify the goods to be coming from a particular undertaking, statements from various trade and commerce associations. Some of the factors to decide whether the mark in question has distinctiveness or not. So, these are the criteria to decide distinctiveness. Now, let us go back to what we have discussed in this session. I said that trademark is something which is visually perceptible. It has this responsibility, role to distinguish goods of one trader from other traders' goods. It represents goodwill, it represents reputation of a product. I already said that trademark can be registered trademark, trademark can be unregistered trademark. Even in cases of unregistered trademark, you have some protection given in the form of passing off remedy. We will talk about passing off remedy later on. But the only point is you get a better protection in case your trademark is registered. We defined what is a trademark with the help of section 21ZB, where we said that trademark is a mark which is capable of represented graphically, which distinguishes goods and services of one trader from goods and services of other traders, which traders use in the course of trade to indicate trade origin. We defined a mark. Mark includes a device, brand, heading. All these are marks. And when we use these marks in the course of trade, it will become trademark. I refer to conventional trademarks, non-conventional trademarks. Non-conventional trademarks can be visual trademarks, non-visual trademarks. Non-visual trademarks are those marks where registration becomes slightly difficult because of the reason that we insist on graphical representation. Meaning of trademark, we also said that there are new non-conventional marks which are getting registration nowadays. For example, 2017 rule provides for registration of sound marks. The registry will ask you to provide the sound marks in MP3 format. I also referred to the motion marks. There are two other categories which we discussed. One is certification trademark, other is called collective trademark. Certification trademark is something which is used by those who are licensed to use it, provided they fulfill the conditions laid down by the proprietor entity. On the other hand, collective trademark is a trademark which is collectively owned by all the members of an association. Now, the key thing here in this discussion was to understand the prerequisites of registration, because that forms the basis for our discussion of section 9 and section 11 in the next lecture. I said there are 4-5 points which are important. It must not cause confusion, it must not contain scandalous thing, obscene material and so on. But the key word is it must have distinctiveness. There are certain things which we need to understand in the beginning itself. The more apt a word is as a descriptive word, less are the chances for that word to be considered as distinctive. A more apt a word is as a descriptive word, less are the chances for that word to be called as a distinctive word. So, what I am trying to say is, a descriptive word essentially is not registrable because it is describing the quality of that product, it is describing the product itself. And such descriptive words, such laudatory words shall not be allowed to be monopolized by few. But that is not all. Descriptive words, although ideally are not registrable, may still be registered if we can prove that it has lost its primary meaning. As Delhi High Court said that because of long use, exclusive use, nobody is coming in the market with the same word, it may happen that a word which otherwise originally was a descriptive word and lacked distinctiveness is nevertheless now eligible to become registrable trademark. Why? Because it has acquired distinctiveness. Some trademarks are inherently distinctive. For example, you must have seen certain invented words becoming trademark. It is very common in pharmaceuticals, in medicine, where there is a drug made of two salts. There is a word taken from salt A, there is a word taken from salt B, some prefix, suffix is added, and there is an invented word. Such invented words are inherently distinctive. Those are registrable. And there are certain words which acquire distinctiveness. Acquired distinctiveness means it acquires distinctiveness by virtue of losing its primary meaning. You see, marks that is not innately distinctive but by virtue of extensive and significant use of the mark over a period of time, the mark persuades the consumer to relate the mark with a product or process or service. It is a descriptive word because of long use. Quality word is a descriptive word. But because of long use, now the trader has persuaded me to relate that word with a particular product. So whenever I hear that word, I don't relate it with its primary meaning, I relate it with the product to which it is affixed or with which it is used. Such examples are cases of acquired distinctiveness. This may not be a very appropriate example, but you may refer to it. Dettol or Dalda, these are brand names, but they have to now bear reference to the product itself to such an extent that even if we buy the same product under another brand name, the image that comes to our mind is that of Dettol and Dalda. That is the kind of meaning which I want to convey. Even if I buy an antiseptic solution belonging to some other company, I go and ask for Dettol, and it is something which we relate to a particular product. It is no more a word which is only a trademark or a brand. We relate this word to the product as such. So this is something which we mean as losing primary meaning, acquiring some secondary meaning, and that is how acquiring distinctiveness. Section 9(1) contains a proviso which allows for registration of such trademarks which acquire distinctiveness, which acquire distinctive character as a result of long use. I referred to the criteria which we will be referring to for the purpose of deciding distinctiveness. The important factor happens to be how intensive geographically, how widespread and long is the standing of that mark, because that is something which helps in a consumer relating that word with the product. Now, in conclusion, we can say that we have understood the basic concepts in the law of trademark, including meaning of mark, meaning of trademark, and the key word distinctiveness. Some salient aspects of criteria for registration was also introduced, which shall be detailed in the next session. We also saw that 2017 rules are fairly progressive. However, further reforms may be needed in the existing framework for creating space for protection of some of the unconventional marks in India. The next lecture shall be on registrable marks, which shall include discussion on Section 9, which provides for absolute grounds for refusal of registration of a trademark, and Section 11, which talks about relative ground for refusal of registration of trademark. So that's all in the basic concepts of trademark. Thank you very much for joining.
Hello and welcome to this piece of literary snippet. Today we are going to read a section from Virginia Woolf's novel Orlando. And the section that we are going to listen to today is perhaps one of the finest descriptions of the winter season in English literature. It is also a very fine piece of what we call fantasy writing. I have made a few changes to the original to adapt it for the purpose of reading. The Great Frost was, historians tell us, the most severe that has ever visited these islands. Birds froze in mid-air and fell like stones to the ground. At Norwich, a young countrywoman started to cross the road in her usual robust health and was seen by the onlookers to turn visibly to powder and be blown in a puff of dust over the roofs. The mortality among sheep and cattle was enormous. Corpses froze and could not be drawn from the sheets. It was no uncommon sight to come upon a whole herd of swine frozen immovable upon the road. The fields were full of shepherds, ploughmen, teams of horses, and little bird-scaring boys, all struck stark in the act of the moment. One with his hand to his nose, another with a bottle to his lips, a third with a stone raised to throw at the ravens who sat upon the hedge within a yard of him as if they were stuffed birds. The severity of the frost was so extraordinary that a kind of petrification sometimes ensued. It was commonly supposed that the great increase of rocks in some parts of Derbyshire was due to no eruption, for there was no eruptions. Rather, it was supposed that they were due to the solidification of unfortunate wayfarers who had been turned literally to stones where they stood. The church could give little help in the matter, and though some landowners had these relics blessed, the most part preferred to use them either as landmarks, scratching posts for sheep, or when the form of the stone allowed, drinking troughs for cattle, which purpose they serve admirably for the most part to this day. But while the country people suffered the extremity of want, and the trade of the country was at a standstill, London enjoyed a carnival of utmost brilliance. The new king directed that the river, which was frozen to a depth of 20 feet, should be swept, decorated, and given all the semblance of a park or pleasure ground, with arbors, mazes, alleys, drinking booths, all at his expense, of course. Frozen roses fell in showers when the queen and her ladies walked abroad. Colored balloons hovered motionless in the air. Here and there burnt vast bonfires of cedar and oak wood, lavishly salted so that the flame were of green, orange, and purple fire. But however fiercely they burnt, the heat was not enough to melt the ice, which, though of singular transparency, was yet of the hardness of steel. So clear, indeed, was the ice that there could be seen, congealed at a depth of several feet, here a porpoise, there a flounder. Shoals of eels lay motionless in a trance, but whether their state was one of death or merely of suspended animation which the warmth would revive, puzzled the philosophers. In short, nothing could exceed the brilliancy and gaiety of the scene by day. But it was at night that the carnival was at its merriest. The nights were of perfect stillness. The moon and stars blazed with the hard fixity of diamonds, and to the fine music of flute and trumpet the courtiers danced. See you in the next episode. of literary snippet.